Welcome back to the deep dive. I'm really glad you could join us today.
Great to be here.
We're diving into something truly fundamental today, an institution that maybe doesn't get the spotlight often, but its impact is huge for millions.
Absolutely. It's one of those foundational pieces.
Right. And our mission, as always, is to take these, sometimes complex constitutional details and make them really clear, really compelling. We're drawing on some expert insights, primarily thinking about the framework laid out in standard texts on Indian governance.
Mm-hmm.
Okay, let's get into it. We're looking at the National Commission for Scheduled Tribes, the NCST. Now, this isn't just like another government office.
No, not at all.
It plays this absolutely critical role in, well, safeguarding the rights and welfare of scheduled tribes. But when we say it's a constitutional body, what does that actually mean? You might be thinking, okay, constitutional body, why is that such a big deal?
And that distinction is key, really.
Yeah, we're definitely going to unpack that. We'll look at where it came from, its purpose, and honestly, the surprisingly wide range of things it's responsible for. It's about how a nation tries to protect its unique communities.
Yeah, and what's fascinating isn't just that it exists, but the whole journey,
Yeah.
how it was created and the specific problems it was set up to tackle.
Right.
This isn't just about laws and regulations on paper. It's a very distinct recognition of specific communities, their cultures, their needs, all within this huge, diverse country.
It makes you ask that fundamental question.
Exactly. How does a nation like India, with all its diversity, actually ensure protection and development for its, well, arguably some of its most distinct and sometimes vulnerable groups? How do you do that fairly?
The NCST is, in a way, an answer to that.
It's a mechanism designed precisely for that, a way to try and bridge gaps and ensure justice.
Okay, so let's start right at the beginning. The basics. The National Commission for Scheduled Tribes, NCST. Our understanding is it's not just another department or committee, it's a constitutional body. Can you break that down for us? What does that mean in practice and why is it so important?
Right. So connecting it to the bigger picture of how India is governed, being a constitutional body means it's established directly by the Constitution itself.
Not just by a regular law.
Exactly. Specifically for the NCST, it's Article 338A. This gives it a unique status. It's different from a body created by, say, an act of parliament or just an executive order from a ministry.
Okay, so it's more permanent, more fundamental.
Precisely. Think about it. Parliament can change laws, governments can change executive orders, but changing the Constitution, that's a much heavier lift. It signals that the mandate of this body is seen as fundamentally important, deeply embedded.
So it's harder to just get rid of or ignore.
Much harder. It underlines the permanence, the fundamental nature of its job. It's like a structural pillar built into the very design of the nation's governance, specifically for protecting and advancing scheduled tribes. It's not just an add-on.
That makes sense. It gives it real weight.
Definitely. Significant moral and legal authority flows from that constitutional status.
Okay, so it has this high constitutional status. What's its core mission then? What's the main job it's tasked with, given that strong foundation?
Its primary objective, really, is to monitor all the safeguards. And by safeguards, we mean all the protections, the provisions that are laid out specifically for scheduled tribes.
Where are these safeguards found?
They can be directly in the Constitution itself, fundamental rights and specific articles, or they can be in other laws passed over time by Parliament or state governments.
So it watches over all of that.
Yes, but it's more than just watching. It also has to evaluate how well those safeguards are actually working in practice. Are they effective? Are they reaching the people they're meant to?
So it's not just ticking boxes, it's assessing impact.
Exactly. It's an active watchdog. But it's also meant to be an advocate, pushing for improvements, and a facilitator, trying to make sure those protections really work on the ground.
Watchdog, advocate, facilitator. That's quite a combination.
It is. And all of that is rooted directly in the Constitution, which gives its work that fundamental legal basis. Governments have to take notice.
Now, here's where I think the story gets really interesting. The NCST, as it exists now, wasn't always there. It actually evolved, right? It
Yeah.
came from a combined body.
That's right. It has a history. Initially, there wasn't a separate commission just for STs.
What was there before?
There was a single national commission that covered both scheduled CAFs, SECs, and scheduled tribes.
Okay, one body for both groups. When was this set up?
This combined commission came into being because of the 65th Constitutional Amendment Act of 1990. It officially started functioning around March 1992 under Article 338 of the Constitution.
And its job was?
broadly, to monitor the safeguards for both SCs and STs. The idea, perhaps, was that a single powerful body could look after the interests of both historically marginalized groups.
Right, so they had this combined commission. It seems logical on the surface why the need to split it up. What drove the decision to create a separate NCST just for scheduled tribes? That sounds like a big step.
It was a very significant step, and it points to a growing understanding of nuance. The key reason highlighted is that, well, geographically and culturally, scheduled tribes are very different from scheduled castes.
How so? Can you elaborate a bit?
Sure. While both groups faced historical injustice, the nature of their problems often differs. SC issues were often tied to caste hierarchy, untouchability, social discrimination within settled villages. STs, on the other hand, were frequently forest-dwelling communities, often geographically isolated, facing issues like losing their land, displacement due to big projects, threats to their unique cultural identity, loss of access to forest resources.
So different sets of challenges, really.
Distinctly different problems needing different solutions. This differentiation was absolutely central to the push for separation. And it wasn't just a theoretical point, it led to practical changes too.
Like what?
Well, in 1999, a whole new Ministry of Tribal Affairs was created. The specific goal was to give a sharp focus to the welfare and development of STs.
So even the government structure started reflecting this need for specialization.
Exactly. It was a clear signal that their issues needed dedicated, undivided attention. A one-size-fits-all approach just wasn't working effectively enough.
Okay, so that makes sense. A recognition that the specific issues STs faced tied to land, forest, culture, remote locations needed their own dedicated focus. Something a combined body juggling SC issues too maybe couldn't provide effectively.
Precisely. It became an issue of administrative feasibility and effectiveness. It was felt that the new Ministry of Tribal Affairs should handle all things ST-related.
And the other ministry couldn't handle both.
The thinking was that the Ministry of Social Justice and Empowerment, which focuses on SCs, couldn't realistically and effectively manage the coordination for both groups, given how different their needs were and the sheer amount of work involved.
Right, you'd need different expertise, different approaches.
Exactly. Trying to manage, say, forest rights issues alongside urban caste discrimination issues under one roof, it's administratively complex. The combined structure was perhaps hindering the kind of focused, tailored support tribal communities needed. Specialization was seen as the way to get real results.
So this growing realization, both administratively and in terms of understanding the distinct needs, leads us to the actual split. How did that happen constitutionally? What was the mechanism?
Okay, so to make this separation official and give it constitutional weight, the decision was made to formally set up a separate national commission for STs by splitting the existing combined one.
And how was that done?
The key piece of legislation was the 89th Constitutional Amendment Act of 2003. This amendment came into force in February 2004.
And what did this 89th Amendment actually do?
It did two main things. First, it changed the original Article 338, which dealt with the old combined commission. But second, and crucially, it inserted a brand new article into the Constitution, Article 338A.
A whole new article just for the NCST.
Yes. And that's significant. It wasn't just a modification, it was creating a distinct constitutional space specifically for the NCST. Article 330A laid the foundation for this separate commission.
So the NCST officially came into being in 2004.
That's right. That's when the separate National Commission for Scheduled Tribes formally started its work, marking a really important step towards more focused governance and protection for tribal communities in India.
Okay, fascinating history. Now that we understand its constitutional roots and why it became separate, let's look inside. How is this commission actually structured? Who makes up the NCST?
It's designed to be a relatively compact body, actually. It consists of a chairperson, a vice chairperson, and 3 other members.
So 5 members in total.
Yes, 5. It's a focused leadership group designed to guide its work effectively without being, a huge bureaucracy. The idea is likely to allow for cohesive decision-making while still representing diverse perspectives.
A strategic task force, almost.
You could think of it that way, yeah. Dedicated to this specific mandate.
And how are these 5 individuals chosen for such important roles? And what about their time in office? How long do they serve?
The appointment process itself highlights the importance attached to these roles. They are appointed directly by the President of India.
By the President, okay.
And it's done formally by warrant under Hisher Hand and Seal. That's a very formal type of appointment used for high constitutional positions, emphasizing the authority behind it.
So it's a high-level appointment process, and their term.
Their conditions of service, including how long they serve, are also determined by the president. Under the specific rules set up for this, the National Commission for Scheduled Tribes chairperson, vice chairperson, and members' conditions of service and tenure rules, 2004, they hold office for a term of 3 years.
3 years. Can they be reappointed?
Yes, but there's a limit. The rules state they are not eligible for appointment for more than 2 terms.
So a maximum of 6 years, potentially.
Effectively, yes. This ensures some continuity is possible, but also guarantees rotation and brings in fresh perspectives over time, which is pretty important for a body like this dealing with evolving issues.
Right, that makes sense. Now let's get to the core of it. What does the NCST actually do? We know its status, its structure. What are its main functions according to the Constitution?
Okay, its functions are really quite broad, covering several key areas. First, it's tasked with investigating and monitoring all matters related to the safeguards for STs, constitutional or legal.
So checking if the protections are in place.
Yes, and then evaluating how well they're actually working. It's about oversight and assessment, like a continuous checkup on how tribal rights are being upheld.
A sort of constant health check on tribal rights. What else?
Second, it has the specific power to inquire into complaints. If there are specific grievances about the deprivation of rights or safeguards for STs, individuals or groups can bring those complaints to the Commission.
So it handles individual cases or group issues too, not just general monitoring.
Exactly. It provides a channel for redressal. If a community feels their rights have been violated, they have a place to go.
That's crucial for justice on the ground. Does it also play a role in, say, development planning? Is it proactive in that sense?
Absolutely. That's the third major function. It's mandated to participate and advise on the planning process for the socioeconomic development of scheduled tribes.
Participate and advise. So it gets involved in policy formation?
Yes, it's meant to be part of the conversation when development plans are being made, both at the central and state levels. And it also has to evaluate the progress of that development. Is it actually helping? Is it effective?
So it's involved from planning through to evaluation.
Right. It positions the Commission right in the middle of policy making and checking if those policies actually deliver results for tribal communities.
Okay. Investigating, monitoring, handling complaints, advising on development. How does it communicate all this work? How are its findings and recommendations put forward?
That leads to the fourth function. It has to present reports to the president. Typically, this is an annual report, but it can submit reports at other times too if it feels it's necessary.
And what's in these reports?
They detail how the safeguards are working, highlight problems, and, crucially, this is the fifth function, make recommendations.
Recommendations for action.
Yes. Recommendations on what the union and state governments should do to implement the safeguards effectively, and also other measures needed for the protection, welfare, and socioeconomic development of STs.
So it proposes concrete steps.
Exactly. It's meant to guide government action.
And is that it? Or can his role expand? Can the president give it other tasks?
Yes, there's flexibility built in. The sixth function allows it to discharge other duties related to the protection, welfare, development, and advancement of STs, as the president may specify.
So it can adapt to new challenges.
Precisely. If new issues emerge that significantly affect tribal communities, the president can formally task the commission with addressing them. This allows it to stay relevant and responsive over time.
That last point about the president specifying other functions is really interesting. And our source material actually details some very specific extra duties that were added later, I think around 2005. These really show the depth they get into.
Yes, those additional functions specified in 2005 are quite revealing. They show a move towards addressing very concrete, ground-level issues faced by tribal communities. They're not abstract. They're about tangible things.
Let's go through them. What's the first one? Sounds like it's about forest resources.
Right. The first one is about measures to be taken for conferring ownership rights in respect of minor forest produce to STs living in forest areas.
Minor forest produce, like leaves, honey, herbs.
Exactly. Things crucial for the livelihoods of many forest-dwelling tribal communities. Granting ownership rights, not just collection rights, is a big step towards economic empowerment and recognizing their traditional dependence on forests.
Okay, crucial for livelihoods. What's next? Something about minerals and water.
Yes. The second focuses on measures to be taken to safeguard rights of the tribal communities over mineral resources, water resources, etc., as per law.
This sounds like it tackles those big conflicts over resource extraction in tribal areas.
It does. Mining, dams, industrial projects often happen in tribal lands. This function pushes the commission to ensure tribal rights are protected, that they're consulted, compensated fairly, or benefit from these projects, rather than just being displaced or exploited.
Balancing development with rights. What about economic development more broadly?
The third function is about measures to be taken for the development of tribals and to work for more viable livelihood strategies. This is proactive, looking beyond just protection to actively promoting sustainable economic options.
Like skill development or supporting traditional crafts.
Could be things like that, yes. Finding ways to improve economic well-being that are sustainable and culturally appropriate.
And displacement. Big development projects often force people to move. How is that addressed?
That's the fourth point. Measures to be taken to improve the efficacy of relief and rehabilitation measures for tribal groups displaced by development projects. It acknowledges the huge disruption caused by displacement.
So ensuring the support they get afterwards is actually effective.
Yes. Making sure relief is adequate and rehabilitation truly helps them rebuild their lives, not just financially, but socially and culturally too. It's about minimizing the trauma and ensuring justice when displacement happens.
Land is so central. Is the issue of tribal land being taken away, land alienation covered?
Absolutely critical, and yes is the fifth function. Measures to be taken to prevent alienation of tribal people from land and to effectively rehabilitate such people in whose case alienation has already taken place.
So preventing future land loss and helping those who've already lost it.
Exactly. Tackling this historical and ongoing problem head-on, aiming for prevention and also restitution or effective rehabilitation.
Okay. And I think there was something about involving tribal communities in forest protection.
Yes, the sixth point is about measures to be taken to elicit maximum cooperation and involvement of tribal communities for protecting forests and undertaking social afforestation.
So seeing them as partners in conservation, not just, people living in the forest.
Precisely. Recognizing their traditional knowledge and making them active participants in protecting the environment they depend on, it's a shift towards collaborative conservation.
And then a mention of a specific law, the Panchayats Act, PISA.
Right, the seventh function. Measures to be taken to ensure full implementation of the provisions of panchayats, extension to the Scheduled Areas Act, 1996, or PISA.
Why is PISA implementation so important here?
PISA is designed to empower Gram Sabhas, the village assemblies, in tribal areas, giving them significant powers over local governance, resources, and customary practices. Ensuring it's fully implemented is key to tribal self-governance and local democracy.
Makes sense. And finally, there was something about shifting cultivation.
Yes, the eighth point. Measures to be taken to reduce and ultimately eliminate the practice of shifting cultivation by tribals that lead to their continuous disempowerment and degradation of land and the environment.
That sounds complex. It's a traditional practice, isn't it?
It is, but it can also cause environmental problems in some contexts today. So the focus here is on finding a balance, working with communities to find sustainable alternatives that empower them economically without harming the environment, rather than just banning a traditional practice. It's about sustainable transition.
Wow, that's an incredibly detailed and wide-ranging set of responsibilities. Now, a body with this much scope needs accountability. How did the NCST ensure its work is reported and, importantly, acted upon? It needs real teeth.
Definitely. There's a clear reporting structure. The Commission submits an annual report to the President.
Every year?
Yes, a regular update. But it can also submit reports whenever it feels necessary for urgent issues.
Okay, so the reports go to the President. What happens then? Do they just sit on a shelf?
No, absolutely not. The President has a constitutional duty to place these reports before Parliament.
Before Parliament, okay.
And this is crucial. Along with the report, the President submits a memorandum. This memorandum explains what action the central government has taken on the Commission's recommendations.
What if the government hasn't accepted a recommendation?
That's the key part. If any recommendations have not been accepted, the memorandum must state the reasons why.
So they have to publicly justify not acting on the Commission's advice.
Exactly. It creates transparency and accountability. The government's response, or lack thereof, is put on record before the legislature.
That's a powerful check at the national level.
Yeah.
What about issues specific to states? How does it work within India's federal system?
It mirrors the process at the state level. If a report relates to a specific state government, The president forwards it to the state governor.
To the governor.
Yes. And the governor then places that report before the state legislature. Again, accompanied by a memorandum explaining the action taken by the state government and, crucially, the reasons for any non-acceptance of recommendations.
So the same accountability mechanism applies at the state level, too.
Yes. It ensures oversight and encourages action right down to the state level where many of these issues play out directly. Dual accountability.
Okay, reporting and accountability are clear. But you mentioned earlier it has powers like a civil court. That sounds like more than just recommending. What does that actually mean in practice?
It's a very significant power. When the NCST is investigating a matter or inquiring into a complaint about rights deprivation, it has all the powers of a civil court trying a suit.
All the powers, so it can compel people.
Yes. It gives it real investigative authority. It's not just asking nicely for information, it can legally require it. This allows it to conduct thorough, credible investigations.
That's quite something. Can you give examples of what kind of civil court powers can it actually use?
Sure, it's quite extensive. For instance, it can summon and enforce the attendance of anyone from anywhere in India and examine them under oath.
So compelled testimony.
Yes. It can require the discovery and production of any document demand evidence, basically.
Get hold of records.
Exactly. It can receive evidence on affidavits, which are sworn written statements. It can requisition public records from any court or office.
Access official files?
It can issue summons for examining witnesses and documents, formal legal orders. And it can handle any other matter the president might specify related to these powers.
So these powers really back up its investigative role.
They absolutely do. They ensure it can get to the bottom of things, gather evidence properly, and make findings based on solid investigation, not just hearsay.
So putting it all together, it's definitely not just an advisory body. It has these real investigative powers, a strong reporting mechanism with accountability built in. And you also mentioned it has a role in policy before things go wrong.
Exactly. Those civil court powers give it teeth in investigations. But beyond that, there's the crucial point that the central and state governments are required to consult the commission on all major policy matters that affect scheduled tribes.
Required to consult, not just optional.
Required. This proactive role is vital. It means the Commission's perspective, representing ST interests, is meant to be considered right from the start when policies are being developed, not just brought in afterwards to fix problems. It embeds their voice in the governance process itself.
Okay, so let's try and wrap our heads around this. We've traced the journey of the NCST, its constitutional foundation, in Article 338A, its separation from the SC Commission because of the unique needs of tribal communities.
The 89th Amendment being key there.
Right. And we've looked at its structure, the chairperson, vice chairperson, 3 members appointed by the president, and its huge range of functions.
Investigating, monitoring, advising on development, handling complaints.
Plus those specific added functions dealing with things like minor forest produce, land alienation, PISA implementation.
Really getting into the specifics of tribal life and challenges.
And then the reporting mechanism with mandatory justification for non-acceptance and those significant civil court powers for investigations. It's a really powerful structure on paper.
It is. It's a fascinating example of how a constitution tries to build in safeguards for specific, often vulnerable populations.
If you stand back and look at the whole picture, the NCST really emerges as this constitutional commitment made tangible.
It does. It's a testament to that commitment. Its evolution shows this growing recognition that scheduled tribes face distinct challenges needing focused solutions.
And its functions are so broad, from individual complaints right up to advising on national development policy.
Exactly. Covering protection, welfare, development, resource rights. It's incredibly comprehensive. This deep dive really highlights how a body with both constitutional backing and specific legal powers is designed to bridge gaps and work towards justice.
It's a complex institution for complex challenges.
Absolutely. A vital part of India's framework for social justice and inclusion. Which maybe leaves us with something for you, our listeners, to think about. Given everything we've discussed, this wide range of functions, these significant powers like a civil court, what do you think are the biggest practical challenges such a commission might face? How does it actually translate these powers and functions into real, tangible improvements for diverse tribal communities across such a vast country?
That's a great question. The gap between mandate and reality.
And think about that accountability mechanism, too. When governments give reasons for not accepting the NCST's recommendations, how might that impact the Commission's influence, its credibility, and its long-term effectiveness in actually driving change? Something to definitely ponder.